more? You still wait? Okay. My name is Shakira Pleasant, everyone. I'm an associate professor at Savannah Law School. I'm going to give you a quick disclaimer. I am a first-year professor teaching full-time, so I'm very excited to be here and appreciate the opportunity to present today. So I'm going to begin with a little interactive exercise. I'm going to pass around a questionnaire that I've given to my students. It's going to take just a couple minutes to fill out, figure 2 to 3. And then after you complete it, I am going to ask for some volunteers.
Are we allowed to look at it?
Yes, you're allowed to. Sorry. I know, right?
Because I'm like, children.
You know, it's a habit.
I haven't gotten like, whatever, I'm doing it.
Here we have it.
Apparently, I'm a wild card. You are just,
Wrap up in about a minute, so you are finishing up. Okay, and time. So, can I get 3 volunteers, please? Okay. 1, 2, who's my third one? All right, so I have Sue, I have Catherine, and who's my third volunteer? Okay, I'm sorry, your name, please? Yes, ma'am.
Nikki.
Nikki, all right, so Sue, Catherine, Nikki. All right, Catherine, since you're closer, can you please tell everyone your name, your undergraduate institution and degree, and then who your favorite lawyer or a lawyer that you respect?
yes, I will. Halfway, I don't know. My name is Catherine Silver Kelly. I went to my undergraduate degree is from Berea College in Berea, Kentucky. My undergraduate degree is history and economics, and the lawyer that I respect is attorney Dave Utley, and I respect him for his thoroughness and problem-solving skills.
Sue Painter, where was this name? Sorry.
Name, I didn't ask your hometown.
Okay, all right, that was the confusing part. I was like, do you mean where I'm from or where I live now? Okay, I'm Sue Painter Thorne. I went to the University of Maryland in College Park and studied anthropology. And I put two lawyers that I admire most. One is not a lawyer, but a judge, which is a lawyer, but Judge Harry Ferguson, who I clerked for because of his compassion and humanity that he shows and that he integrates into decision-making, working with his clerks as well, which he's also a good writer who cares about writing and yells at law school deans about not emphasizing legal writing enough, so he's a good guy. And another is Tom Welsh, who is a partner that I worked with in practice, who emphasized, and the thing that I liked about him is he emphasized not being oppositional for the sake of opposition with opposing counsel, that there are some things that you can say yes to and you're not betraying your client, and it eases the relationships between the attorneys, and then they return the favor, and even when they don't, responding with grace and being collegial and developing your professional reputation. That's one of the most important things you do as a new lawyer.
And Nikki?
I am Nikki Williams. I went to undergrad at Transylvania University in Lexington, Kentucky. We're right close to Maria. And I can't remember what else I'm supposed to say. I was a psychology major at Transy. And I have two lawyers that I greatly respect. One of them is my husband. He is a prosecutor, and I respect him for many reasons, but professionally because he is able to adapt very well no matter what the circumstances, the types of cases he has, and the types of people he interacts with changes greatly, and he's able to do that no matter if his victim is a long-term Georgia resident or an immigrant from Vietnam. He's able to empathize and to work well with them. And also he has a true servant's heart. He feels like it is his duty to seek justice, but to do it in a way that's fair for all parties. And he has a great sense of duty to mentor the younger attorneys that come along. And then the second attorney is Terry Walsh, and he was one of the first partners I worked for when I worked for Alston & Bird in Atlanta. And he's a very accomplished trial attorney, but what he's most known for is his dedication to serving those people and having excellent representation for those people that need attorneys the most but can least afford it. And he really made a big impression on me as a young attorney, telling me that that was our responsibility, that we could not look to others to serve the needs of others. We need to look within ourselves and be willing to serve. So those are my two attorneys that I particularly respect.
Well, thank you for sharing. Part of the reason why I started off my presentation with that is because that is actually the questionnaire that I hand out to my students the first day of class. And what that does is, what happened when I came into Savannah Law School is I had a bunch of 3Ls and 2Ls who already knew each other, but I was a new kid on the block, and so I didn't know anything about them. And so to gain that familiarity with them, I asked them that questionnaire early on. It also helps me gauge their experience and like you said, who they admire and what their values are, because when you are teaching legal writing or skills, you do develop a close-knit relationship with your students. And I think it's important to get to know them on a personal level, as well as a professional level, because they will be our colleagues. So, that said, when I submitted the proposal for this presentation, like I said, I am a first-year professor, so I previously taught legal research and writing, and I'll get more into that a little bit later, but I never taught pretrial advocacy. So when I thought about this presentation and used the Prezi, I thought about the road to practice. So you have your visual of a road with different stop signs and things to maneuver around. And it's a road that we've all traveled. And it's our jobs as professors to kind of help guide our students around the different signposts, to be able to analyze what's coming next, to be able to evaluate when to concede and when not. So I thought this was kind of a good illustration moving forward. And one other thing like say, kind of like GPS, we as the professors are the ones who are guiding them. So if you think about it that way, it's kind of a car going down this journey together. It helps our students out. So the best teachers use their knowledge to develop instruction and organize concepts so their students can understand. So from my vantage point, my knowledge was based on my career prior to that, law school, and things that I did. So here's just a snippet of my CV. Since I didn't answer the question here, let me tell you briefly about me. I am from Sacramento, California. I went to undergrad at Chico State. I was a political science major. And one of the lawyers that I actually respect was Johnny Cochran. I think he was a great orator, and I wanted to be like him. So that's just a little bit about that background. As you can also see, prior to coming to Savannah Law School, I was an adjunct professor at the University of the District of Columbia for 4 years. So in addition to practicing law, I was teaching at the same time, which was my introduction into the academy. And then lastly, I worked for the Office of the Attorney General, and this was just one of my positions in the government practice. I was a government attorney for about 8 years, but at this particular position, I had exposure to various areas of the law, the Americans with Disabilities Act, the Sheppard Act, and basically really was able to cut my teeth in civil law and motions practice. So, with regard to students and how I approached this class and developed it, buy-in for me was extremely important. I remember Terry mentioning earlier when we were talking to the judge about getting pushback. And so one of the other experiences I had that was not on the slide was I took a development course or a leadership course in DC, actually right before I moved to Savannah, and I had to complete it right after I moved. But one thing we learned about was getting buy-in and change management. And so when I thought about this, and I was visualizing, okay, where am I going to go in this pretrial course? How am I going to get my students to want to travel this road with me to help prepare them for practice? Because that's my goal, pretrial advocacy. So I need to make sure that I had them on board with me and I had to buy in. So one way I did it was the initial questionnaire. Another thing that I did, and you'll see a snippet of this, is midway through, I actually asked them some questions about how they liked the course, what they disliked about the course, and any other constructive criticism that they could provide me. Because at the end of the day, I, like them, are a lifelong learner. And so if my focus is them, and they are always my focus, then I need to make sure that whatever I'm doing in the classroom resonates with them. And they actually took to that, not just with the survey, but one of my students, because I'm new to Georgia, I'm not licensed here yet, she works in the Chatham County Courthouse, and a lot of the things that we did in class, she would give me samples. So I really, really appreciated that. So this is the survey that I was talking to you guys about. And as I said, you can read it for yourself, but some of the things that we talked about in class and some of the activities that we did were to get them in the mind frame of what is practice like in Savannah, Georgia, and specifically in Chatham County. Now, the book that we use in our class is Linda Berger and colleagues' pretrial advocacy course. So it focuses on both criminal and civil law. Mind you, my background is more in civil law. Have not practiced any criminal law in my life. I did have a brief externship when I was in law school at the U.S. Attorney's Office, but again, that was brief and I was a first year, so I knew a little bit, but not enough. So what we did in our class is we structured the assignments such that they got a real-world approach. One thing I did probably the first week of class, and again, having that buy-in allowed me to be flexible. I had them go to the Chatham County Courthouse. Why did I do that? Because we've all looked up to lawyers, we've probably emulated some lawyers, and I needed them to know in person for themselves who was an effective attorney and who was an ineffective attorney. And then I had to come to class and do a free write about that. In addition, I had them write up 4 assignments. We did a criminal motion, we did a demand letter, and we've done a motion for summary judgment. And then I also had them write kind of a client letter in addition to doing other oral advocacy things. All of the things that I set up on the syllabus, completely instinctive. I didn't know until I started preparing for this presentation that a lot of the things that I thought they needed to know because those are things that I thought were useful for actually best practices. So, trust your instincts. That is the theme for today. Trust your instincts. So, let me stay on this slide for a minute because the makeup of my class, I think I may have alluded to this. I had 3 L's and 2 L's. So at Savannah Law School, the 3 L's, I'd say based on their substantive knowledge, are far surpassed the 2 L's. The 2 L's were just getting evidence. And in a pretrial advocacy class, it reaches across a curriculum. You have to recall civil procedure, criminal law, criminal procedure, your legal writing course. And for my students, a lot of them hadn't done a lot of substantive writing since their first year, if they didn't have the expertise or the experience during their experiential learning, internships and externships. So I had to really gauge who I was dealing with. And I made some adjustments because my 2 L's, as I said, weren't far along like the 3 L's. And that's been a learning lesson for me because what I now know in terms of designing this course and moving forward, 1, I know I want to streamline it to make it a little bit easier and have more modules. 2, I know that most of my students are probably going to go out and hang their own shingle. And so the things that we've been talking about today are in tune with exactly what I'm teaching and continuing to develop in this course. I'm still going to rely on my instincts because, as we all know, we do know a little bit better and they are like babies. But just like a baby or a toddler, as they start to kind of form their opinion and have their own identity, I don't want to leave them out of the mix. But I also want them to move towards having better expertise. So, how do I want to continue to do that? Again, I have probably 8 years of practice experience, not necessarily in Georgia, but the skill set is still the same. So another thing that we did in our class this semester is, are you guys all familiar with Chris Brown? No? Okay, Terry is familiar with Chris Brown.
Singer
So,
Chris Brown? Yeah.
Yes, okay,
Yes.
so Chris Brown, the singer, I'll go to the domestic violence thing for a quick minute. He had the whole thing with Rihanna. Exactly, see? So, he had a domestic violence dispute with Rihanna. Move fast forward to 2013, and there was a case in the District of Columbia while I was still living there where Chris Brown allegedly assaulted an individual, a guy by the name of Mercer Isaacs. Chris Brown was arrested, he went to jail in DC, and the U.S. Attorney in DC brought charges against him. Now, why am I giving you this backdrop? Because remember, my pretrial advocacy course focuses on both civil and criminal law. So we had a criminal case with Chris Brown, a real life case. It wasn't just a fact pattern, it wasn't something out of the book. It was something that they knew for themselves and they could get their teeth around it. And then we saw the progression of that case from the criminal realm to the civil realm, because what ended up happening was Chris Brown, although months later, pled guilty to the charges, but Parker Isaacs sued him and his bodyguard for $1 million in a civil suit. And so basically what we did in our class is we used that real life case to kind of supplement our casebook, to say, okay, here is a situation where you guys have to strategically think about what you're going to do in the criminal case that will probably impact you in the civil case. Now, ultimately, the case settled, and again, with the buy-in, one of my students actually told me and sent me the clip on TMZ, he settled the case for $100,000. But when we talked about it, when we went through it in class, and we actually did an exercise where I had them in our 3-hour block take the complaint and write an answer to it. Again, that was just a snippet of time, but I wanted them to at least get some practice with it. And that was something that they appreciated. I'm actually going to go for that really quickly. On the last line, they wanted to have more fact patterns, and they wanted them to be more realistic. Chris Brown was a realistic case. It was real life. It's something that happened. It's something they get their teeth into. So my goal in further developing this course is to have more real life cases like that, in addition to the casebook that they can use to actually help them simulate, okay, what is it going to be when I get to practice? Let me think about this, because as we all know, you do a lot more work on the front end than you do on the back end. And so if you're prepared, that's key. So, one of my colleagues, I don't know if you guys don't know Elizabeth McGalley, one of the best practices for instruction, introducing practicing lawyers and judges into the classroom. Again, I did not have criminal law experience. I know my limitations. So Michael Bruckheim is an attorney in DC. I asked a friend of a friend, hey, do you know someone who's worked on both criminal and civil cases? Why was he important? Because he's actually done that. He had a case in DC where he had a criminal client where he decided not to take certain action, allow the case to move forward against an accuser of his client. That person pled guilty, and then he filed a civil suit. I wanted my students to hear that from him and not just me, because sometimes you need to hear it from a different source, not just your professor, in order for it to click. So I try to introduce other individuals to give them a different perspective. Vicki Carlton Sadler, another colleague who's visiting Savannah Law School. She had experience in depositions. I had experience with interrogatories and written discovery, but not depositions. So I brought her into my class for that purpose. Unfortunately, because of time constraints, we couldn't do a deposition this last semester, but I'm actually looking for that for next semester, because I do understand that it is something that most students don't have experience with, and quite frankly, most of my colleagues haven't even done it until 6-7 years out. And then last but not least, Elizabeth, a criminal prosecutor criminal defense attorney in Florida. So when we were in the criminal aspect of the case, Elizabeth came in and provided her insight on bail hearings, and from the defense attorney side, how you would plead a certain case or how you would try to negate or how you would essentially try to prove that the bond that was put forth needed to be reduced for your client. Skype. So teaching has allowed me to be very creative, kind of like with this Prezi. So Skype came in handy with respect to also introducing lawyers into the classroom. So Michael Bruckheim was physically in his DC office, and I Skyped him into my class. I have another colleague, Carlton Davis, who's a prosecutor in Sacramento, who I've known forever. And when I had Elizabeth come into my class, he talked to the class before her, again, Skyped in. So the students were able to have some interaction with him through technology. I mean, imagine 20 years ago when we didn't have this, and maybe I would have had to fly him in, or I would have had to impart his wisdom on them, but it's not the same as hearing it directly from him. So, as I look forward towards continuing to develop this class, and as I said, I'm trying to streamline it, a lot of the things that I am incorporating, as I mentioned, strictly intuitive, strictly instinctive. But flipping the classroom, have you guys heard of that concept? Yes, okay. So one of the pieces of feedback that I got from my students midterm was, we want more theory. We are talking about a whole bunch of different concepts that maybe they need a refresher on or things like that. I have a 3-hour block, 1 day a week, 14 weeks in a semester, and I'm teaching basically pretrial ad in 2 substantive areas. Time is not really on my side. So, with the benefit and expertise of Susan Landrum, I'm going to try this. So keep your fingers crossed for you guys. And I just want to show you a quick YouTube video about flipping the classroom and what it can do for us.
I'm Aaron Sands, and I teach science here at Woodland Park High School. My ultimate goal, I guess, as a teacher is to help students become learners who can learn for themselves and by themselves. One of the problems that I was guilty of even prior to flipping my classroom around was the classroom was centered around me. I told them exactly what to learn, how to learn it, what assignments to do to learn it, and when to learn it, and how to prove to me that they learned it. I don't do that anymore. You change the place in which content is delivered. Instead of standing in front of a class and delivering, here's how you do this type of problem, here's how this works, I deliver that direct instruction now asynchronously at home through these videos that we make with Camtasia Studio.
I'm still whole.
Oh, you can do that
the last step, they were already whole numbers. We had 1, 1, and 4. Here we don't have a whole number. So here's a few little tricks when you need to multiply by whole numbers. If one of your numbers ends in 0.5, you're going to multiply by 2.
Something 0.5 times it by 2.
Right.
Okay, write this down, guys.
Yes. If something ends in 0.3 or 0.33 or 0.66, you multiply by 3.
Kids come to class, they don't show up to learn new stuff, they show up to apply the things that they learned at home and to ask me questions about the things they learned at home. So now they can have my lesson, if you will, but I would normally have stood up and lectured to them in class with some added features, they get that at home. Then what they were expected to do for homework is now what they do in my class. Life is different for me because I no longer am the guy who stands up in the front of the classroom and just yaks at a student for an hour, or however long the class is. Now, I walk around the class and I help kids. I'm a tutor, I'm a guide, I'm the putter outer of fires, whatever it happens to be in my crazy chemistry class. I walk around and do that. I don't stand up front and teach to be kind of the traditional model. I'm Aaron Sams. I'm a teacher, I'm a dad, I'm a husband, and I love Camtasia Studio.
I thought that was so cool. Okay. And as I get ready to wrap up, the goal. What is the goal here? So as educators, we want to give our students the tools and try to teach them to be effective colleagues. And so my small part in this, and my time is not done, is to make sure that I'm using all the tools at my disposal, my instincts, my experience, to help them become practice ready. And I believe that flipping the classroom will give me more time to help them build those skills and to allow them to have a portfolio of things that they've written once or twice, of oral advocacy skills they've been able to practice in the safe confines of school before they graduate. Thank you for your time, I appreciate it.
Well, I'm Jennifer Sheppard. I know it's a little later in the morning, but welcome to Mercer, our one-day workshop. Today I'm going to talk a little bit about maximizing experiential and other practical skills throughout law school. We do some of that, but I think that throughout the curriculum we could do a better job of that. With that in mind, I'm going to talk a little bit about the ABA standards that were recently adopted, so if you could bear with me while I kind of drill through the language that they use, I'll get to my more original thoughts in a moment. With regard to ABA Standard 303, it addresses the curriculum and the curriculum requirements for law schools. And the ABA has now said that law schools are required to offer a curriculum that allows each student to satisfactorily complete at least the following, among other things, one or more experiential courses totaling at least 6 credit hours. The ABA has defined an experiential course as a simulation, a clinic, or an externship. With regard to the requirements for experiential courses, the ABA has required that they be primarily experiential in nature, which kind of define the thing by the thing. Good drafting there. Be primarily experiential in nature, and also integrate doctrine, theory, skills, and legal ethics, and engage students in the performance of one or more of the professional skills identified in Standard 302, which I will discuss in a moment. Develop the concepts underlying the professional skills being taught. Provide multiple opportunities for performance, and provide opportunities for self-evaluation and reflection. Standard 302 requires that law schools help students attain competency in the following areas: knowledge and understanding of substantive and procedural law, legal analysis and reasoning, legal research, problem solving, written and oral communication in the legal context, the exercise of proper professional and ethical responsibilities to clients and the legal system, and D, other professional skills needed for competent and ethical participation in the practice of law. What does D mean? Well, Interpretation 302 tries to identify some of these skills. They've identified skills such as interviewing, counseling, negotiation, fact development and analysis, trial practice, document drafting, conflict resolution, organization and management of legal work, collaboration, cultural competency, and self-evaluation. Not a small list that we have to help our students attain competency in. Now, I want to talk a little bit about the courses at Mercer that we're offering. And I'm just using Mercer as sort of an example. All law schools offer a variety of things that can satisfy these requirements, but I'm just going to stick with Mercer because that's where I am, that's what I know. Mercer offers a variety of experiential learning experiences, Our clinical offerings include the Habeas Project and the Public Defender Criminal Defense Clinic. Our externship program offers a variety of externship possibilities. You can go with public interest practicum 1 or 2, where students are placed with district attorney's offices, public defenders, those sorts of organizations. We also have the judicial field placement, which I teach in, where we, of course, place students with judges like Judge Colvin, who was here earlier today. And then we have the legislative field placement, which is offered in Atlanta, offered in Atlanta this coming semester. In addition to our clinical offerings and our experiential offering, or our externship offerings, we also have a number of simulation courses. At Mercer, we offer Introduction to Counseling, Introduction to Dispute Resolution, Case Settlement Negotiation, Trial Practice, Advanced Trial Practice, and a variety of competitions. So mock trial, moot court, a client counseling competition, and a variety of others through the Mercer Advocacy Council. Now, those are our sort of truly experiential classes. Offering truly experiential classes can be time-consuming and expensive. It's very resource-intensive, and so law schools are going to necessarily be limited on the number that they can offer. Now, some schools have more money, they can offer more. Some smaller schools with less money would have fewer offerings. And so what does that mean for the students? Well, just because we don't have a truly experiential offering throughout every class in the curriculum doesn't mean that we can't integrate some of this experiential learning and these other practical skills into our more traditional classes, or what some people would call doctrinal classes. The doctrinal classes are already talking and teaching students about the doctrine and the theory behind substantive and procedural law. They're dealing with legal analysis and reasoning, and so it would be easy for them in many instances to just integrate more problems based on real cases, and to integrate some of these other skills such as problem solving, written and oral communication, document drafting, fact development and analysis, interviewing, counseling, and conflict resolution. They don't have to do it all. They can just do pieces of it, whatever fits best into the context of that class. And with that in mind, I'm going to look at some of the courses offered at Mercer and show what some of our professors are doing to integrate some of these skills into the more traditional classes. The first class that I want to talk about is Administrative Law, offered by Professor Linda Jellum. Professor Jellum has the students in Administrative Law complete what she calls the Notice and Comment assignment. This Notice and Comment assignment requires students to research a pending regulation, select a pending regulation based on some special expertise that they may have, and draft a comment to the agency. She tells the students to select a regulation to comment on based on any special expertise that they have. I mentioned that earlier. Mostly, for most of the students in the class, this expertise comes from what they've learned in administrative law previous to this assignment, or from statutory interpretation, which all Mercer 2Ls are required to complete in their, second year, since they're 2Ls. However, some students, particularly the non-traditional students, have expertise from other areas in their life before law school, such as the job that they had before or whatever. So teachers, farmers, bankers, insurance agents, whatever it might be, they can take the knowledge that they earned and that they garnered from that experience and apply it to the proposed regulations and whether they think it's a good thing or a bad thing for the area, and to write their comment. Professor Jellum then requires the students to give a class presentation where they explain to their classmates and their colleagues how they picked the topic they picked, why they selected it, what the regulation will do, whether they agree or oppose it, and that sort of thing. The students then submit their comment to her. She gives them feedback to help them kind of further refine their analysis. She gives the papers back, they revise it, and then they submit their comments that are pending to their comments on the pending regulation to the agency. Now, once they do this, it becomes part of the permanent record, right? Every now and then, they've been fortunate that once they've submitted it, there's been some other step. For instance, one year, the agency contacted the student and wanted some clarification. And so that was a great lesson to the students that this could happen. Another year, a newspaper reporter wanted to write an article on the pending regulation, what it would do, and talk about the opposing views and the views in support of the regulation. And so a student was contacted, and the reporter asked that student if the reporter could quote him or her. And so that was another great experience for the students. They get to see that this stuff is out there, it has a real effect, and it's not just an exercise in futility, I guess. So, in addition, this assignment is great because it helps the students understand the notice and comment process, what its purpose is, how you go about it. It also helps the students sort of see what it is that they might be doing on a daily basis if they decide to have an administrative law practice. At some point, you're probably going to have to do this for your client, and so it's probably helpful to know how to do it. And so that's the purpose behind the exercise, and the students really seem to like it and appreciate it, particularly when they get, the agency contacting them for a report. Now, in addition to the notice and comment exercise that she has the students do, she also requires them to do some other smaller exercises. And the goal of these exercises is to help students see that administrative law is not just an abstract theory, and that it has actual practical daily effects. And so with that in mind, she has two different assignments. Now, these aren't truly experiential learning sorts of things or practical skills, but it's good because they actually help the students kind of get their teeth around how this is affecting people on a daily basis. They don't always understand or see the practical effects of the abstract theory that they're learning, and this is a good way to bring it home to the students. So the first assignment that she does is sort of, I've given it a name. She didn't actually have a name for it, but I've titled it, How Does Administrative Law Affect You? And this assignment requires students to bring in one item that has an effect on us on a daily basis. And students had brought in a number of things. They brought in social security cards, driver's licenses, medications, food. You can't buy food without it being regulated, and so she has them bring it in and then talk about it a little bit. They share what they brought with the class and all of that. One person even brought in recently protein powder for all those weightlifters and people who have to gain weight. It's good to know that stuff's regulated. Yay! At least if it's regulated in a good way. So that's the first exercise that she has them do. The next exercise I've also titled Administrative Law in the News. And this she requires each student throughout the semester, not all at the same time, to bring in one news article that covers an administrative law issue. They bring it to class, they talk about it with their colleagues, they tell them about the regulation, what the issue is, and whether they think it's a good or a bad regulation. And so by doing this, she sort of helps the students to see this is a real thing. When we're in high school, at least me, I wasn't particularly great with math. And I would sit in pre-calculus and I would say, how am I going to use this in my everyday life? I get addition and subtraction, but all this other stuff, what am I going to do with this? I'm not going to be a physics person. And so I'm sure our students are thinking this sometimes in legal writing and in other classes, and this just helps them in administrative law to see how it's going to impact them and what use it's going to have every day. The next class that I want to talk about is Civil Procedure, taught by Professor David Rissick. To help the students see the practical rather than the theoretical aspects of civil procedure, which we all see, it's easy to see the theoretical part when we're just learning about the rules, but to see the practical effect, Professor Rissick has the students draft the complaint and the documents, the filing documents that accompany the complaint. So for instance, the summons or request for waiver, the civil cover sheet, they write a check, and a corporate disclosure statement. In addition to requiring the students to draft these documents, they also have to comply with the local court rules of the jurisdiction. And so it requires the students not only to find those local court rules, but to read them and properly interpret them and ask questions if they don't understand. And so this is a way that Professor Rissick tries to combat that. Here's civil procedure in theory. I talk to my students in my externship class about their work with judges, and I always tell them, you know, you're going to learn from this class that the civil procedure and criminal procedure aren't really that hard. It seems hard in civil and criminal procedure class because it's in the abstract. But when you see it in context, it all makes perfect sense. You're like, duh, why didn't I ever understand that? And so this is his attempt, at least in one small way, to introduce them to seeing a complaint, seeing these other documents, drafting them themselves, and that sort of thing. The next class that I want to talk about is Professor Scott Kitshaw's immigration practice. Now this is going to be a mouthful. He described his class, and I'm going to read it verbatim because it's beautiful. Immigration practice is a simulated immigration practice experience in which the students perform all manner of lawyering tasks in responding to detailed factual scenarios drawn from actual case files concerned with obtaining family-related or employment-related immigration benefits. It's a mouthful. I couldn't figure out how to make it shorter, so I just used his words. And it's a great description. And so the course essentially focuses on family-based immigration and immigration practices and procedures, and reinforces issue spotting with regards to admissibility, removal, and consular processing issues. Throughout the class, the students are expected to develop options for achieving the specific immigration goals of their clients, while also spotting red flags and any questions that they need to resolve before they can do what they need to do. The strategies are tested through the traditional professor-student interaction in class, but also through client consultation role-playing. He also has the students prepare documents before class, ranging from an agreement letter to a form and the supporting documentation. So he said for almost every class, they have to do some kind of writing experience that relates to what it is they're learning about. He also invites a number of practitioners to the class, and he asks them to provide the class with the real case files that they had or other practice examples ahead of their visit so that the students can try to work out the strategies beforehand before they get to see how it actually operated and was resolved in real life. The next class that I want to talk about is summary judgment practice taught by Professor Jim Hunt. Throughout the morning we've heard a lot of people talk about teaching students how to draft summary judgment and that sort of thing. And this is one class at Mercer that attempts to do that. That does do that. And so Professor Hunt provides the students with a 500-plus page record. The record has a variety of documents in it, ranging from the pleadings, interrogatories and responses, and 10 or so depositions, some of which are from experts. He put experts in quotations, but from experts. The documents are from a real case. It's usually a tort or a contracts case, and it's a case that settled before trial, and so there's no opinion in the case, and there are no briefs with the legal arguments in them. So the students have to figure that out all by themselves. He has the students complete essentially 3 assignments. The first 2 assignments are sets of facts. One in support of a motion for summary judgment in the case, and one in opposition to the motion for summary judgment in the case. These are relatively short. They're 10 to 15 pages in length. And then the final exercise, the final assignment, is drafting the brief in support of the motion for summary judgment or in opposition. So they don't all draft the same thing. There's some on one side and some on the other. And then he has them give oral argument in class on the case. Now, what are the benefits to the students? There are primarily 2. There are a lot of benefits, but these are the 2 primary ones. The first one is that the main benefit is that it has the students working with the often confusing world of facts and fact development and organizing and gathering. Many students have been told, you have to tell a story. You know, tell a story in legal writing 2, tell a story. But they don't really know how to do that from a large collection of discovery material. Even in legal writing 2, where you provide them with a record, Often when we do it, it's a smaller record, 30 pages or less, not 500 pages that they have to wade through. To them, this is a huge amount of discovery. And so he does this to get them used to it so that they see how you go about the process of narrowing it down, finding out what's important, all those things. The second benefit is that it allows students to understand how lawyers do dispute resolution based on discovery materials. Given that 98% of the cases, civil cases anyway, tend to settle, he thought it would be a valuable thing for them to learn how to make arguments based on the facts presented through discovery. And to also think about how you would negotiate a solution or negotiate a settlement based on the information that you're being provided through discovery. The next class that I want to talk about is Accounting for Lawyers, and this is taught by an adjunct here, Professor Ivy Cadle. Professor Cadle uses actual situations and has developed a sort of Larry lawyer problem set. And using that, he requires the students to think about actual scenarios that have happened and to determine the proper technique to account financially for that situation. The students prepare bookkeeping records and financial statements based on the actual transactions that would occur with clients or within a law firm. Professor Cadle also has experts in a variety of areas such as law practice management, tax accounting, valuation, and forensic accounting. He has them come speak to the students and provide them with case studies based on their own practice experiences. So he uses his own personal experience, but then his expert's experience supplement that as well. And then the final class that I want to talk about is taught by our very own Karen Snedden. It's Trust and Estates Drafting. And throughout the semester, the students essentially work through a client representation, from drafting the initial client intake form to drafting the disengagement letter. The exercises that she has them complete throughout the semester, there's several actually, it's pretty extensive. And so she has them draft, of course, the initial intake questionnaire, the engagement letter, the will, a codicil, a lifetime trust, a financial power of attorney, an advance directive for healthcare, and a disengagement letter. And so she pretty much covers the gamut of what they're going to run into in practice as a trust and wills lawyer. Any examples from your own schools or any questions that you have? Anybody here from Georgia State? I have. Oh, tell me I haven't. Oh, no. It was this nice email that actually caused me to think about this presentation at Mercer. Someone had sent an email about all the different courses where people had incorporated experiential experiences into the classes at Georgia State. There's apparently some beautiful video where they talk about these things. Yes, there is. I'm not crazy.
Yeah, that's true. That actually happened.
Do you remember any of the things on the list? Because I remember reading through it. It was quite extensive, and I really liked some of the ideas. I just forgot to bring my email with the list.
I cannot think of any specific examples outside of our collection, but I know that there has been a big push from the dean down to, follow the trend and comply with these new ABA requirements. So in our group, Jennifer Chavarro and I are developing a third-year class. We won a grant over the summer for an innovative teaching grant, and we are developing a third-year class called Practice Ready Writing. So that's how we are trying to tackle this.
Okay, and in Practice Ready Writing, what are you going to have them draft? Do you know yet?
We're working on it. We're still working on the syllabus, but we are going to have, there is also a required trial advocacy class, so we are trying to shy away from summary judgment and depositions and trial practice and move more into some transactional work. So we'll have them do a memo, we'll have them do lots of emails. This is secret, but we are going to have things that are so experiential that they are not going to know how to handle them. For example, we'll give them a couple hours to complete an assignment, but they're going to get a phone call in the middle of it.
Nice.
you know, and they're gonna get interruptions in the middle of it. There's gonna be a surprise emergency in the middle of it. Because that's
Welcome
what
to real
happens
life.
in practice. So we're working on some of those things as well.
Oh, yeah. So when you incorporate some of these experiential aspects into the doctrinal class, then does it count then for the ABA goes to the 6 credits, or it does not?
I don't think it does, but what we thought at Mercer was, just because it doesn't count towards our 6 credits, doesn't mean that we shouldn't be supplementing their experience and their education in this way. And if you do it in each of these classes, eventually you're going to reinforce something that they got somewhere else. And so even if they didn't get it in their experiential class, they'll have gotten it in 1 or 2 maybe other classes, and they'll say, oh, a pattern. And so that should help. And it also will help in terms of just making the theory for almost every class more real. I know a lot of students just don't get certain classes. Like, how does this affect me in daily life? Or what would I do with this? Like, I'm getting a lot of theory and that's great, but what do I do with it? Terry, you had your hand up?
Oh, you inadvertently left off my social justice lawyer.
I'm sorry, I didn't mean to. You didn't respond to my email.
But it is a simulated impact litigation clinic.
Okay, I wish I had known that, because I like simulations. Do you want to tell us a little bit more about it?
Essentially, students come in, and it's very labor intensive for me because I draft individual case files according to their social justice interest. So I get everything from voting rights to click wrap agreements and consumer protection issues. And so I draft them their individual case files, and we do a lot of work with working through the litigation if it's in front of an agency, if they have to deal with Greg. So it's very responsive to the students, and they do a lot of different exercises that, you know, everything from doing, annotated research lists to kind of help me and guide me to help them to write, because I do a whole case file. So it's like all kinds of pleadings and letters and every student's file. So to help me do that. And then they do evaluation memos, and they do briefs, and they do appeals, and so they do just about everything you would do that have to have an impact litigation.
Is there any interaction amongst the students so they see what each other's doing and learning?
Yes, we do case presentations, and so they do presentations on why they picked their topic, what interested them, and then how their litigation is going.
Awesome.
It's fun, we have a lot of fun.
Yeah, well, it would be just like an experiential class where they're all talking about their positions and what they're learning and seeing, and they're all learning and seeing different things, but they learn from each other then that way. Even in a simulation, so that's cool. I like that.
Question for you. I love all of the courses that you put up on your slide. I love hearing about these courses. And one of the things that, you know, our faculty is sort of in the midst of a curriculum change, upheaval,
Overhaul.
Yeah, exactly, right?
Aren't we all?
And, you know, and of course, the ABA regulations are factoring into our discussions. And in talking about how do we, you know, encourage more simulation-based teaching, one of the things that comes up is that, of course, simulation-based, you know, it's simulating real life of lawyers, which means lots and lots and lots of writing. And my colleagues have expressed some real concern with their ability to effectively give feedback on written work. Is there anything you guys have done? You know, the legal writing people have, I mean, you know, we've got seminars, we've got conferences, we've got each other. You know, how can we kind of help our doctrinal colleagues, you know, be prepared to take on sort of this new role?
We haven't done that at Mercer yet, but just off the top of my head, we have all these different conferences and stuff that we go to, and so maybe as part of faculty development, legal writing folks who volunteer to do it, who choose to do it, you know, it shouldn't be mandatory, can say, well, I'll do sort of like a CLE on how to give feedback. And so I know because several of us came all at the same time, Sue Painter-Thorne, Karen Sned, and I, we all came the same year. And so Linda Edwards was here at the time, and she had sort of like a little meeting where she talked about how you create assignments, how you give feedback. She had us give some feedback, she looked at it, she gave us all sort of anonymous advice and that sort of thing. And so we could probably do that for our colleagues. And so I know what they want to hear is that, well, we will do it for them, but no, alas, no, that will not happen ever. And so what we can do though is give them some of the training that we've had from our conferences and from watching presentations and that sort of thing. And that's just one way that we could do it. It'd be just like we would teach anybody else, right? Associates, we'd have a CLE, partners or judges, we might have a CLE where we train them essentially. And so we could do the same thing for our colleagues.
That's also got to come from the top.
Yes, it does have to come from the top.
Goes without saying.
To do it at all has to come from the top. And also if they're going to have simulations, true simulations, it has to be limited in the number of students that they can have. I mean, you can't have 30 students writing all these documents. They just can't do it. And they might not realize that. That's something we have to explain to them. You're going to need a cap. And so here, you know, once you've got the cap, you have this many students, you can probably do this amount. Here's sort of how it's going to happen in terms of giving feedback and that sort of thing. It'll vary based on what they're having them do. But they don't have that experience that we have. And so they might be pie in the sky and all gung-ho and just kind of go a little overboard. Like I direct the certificate program, like I said, in advanced writing groups, and I talk with adjuncts, and I have some that want to do 2 motions for summary judgment in a 1-hour class for 14 weeks. I'm like, I would suggest you not do that. And they always have to learn for themselves, but then they're like, holy cow, you were right. I should have not done that. And so then they go back to 1. And so it's just, if you haven't done it before, you don't know how much time it takes.
I've heard doctoral professors kind of push back against giving feedback mid-semester because they've seen legal writing professors experience with that. And I feel like sometimes we're the lightning rod because throughout the semester we're giving feedback, and especially for one else, for some of them it's the first time they've ever gotten really negative critiques of their work. And my favorite
But
comment,
what do you mean? I'm an excellent writer.
Yeah, well, my favorite comment is that they're doing well in all of their other classes.
Yes.
Which is more crazy to get when they say they're not. But I think with doctoral, but we don't want any part of that. We'll let you continue to do that.
And one thing I was going to add to that too is, like you, Christine Jones taught me how to critique and not be ultra harsh, but constructive. But I found with pretrial ad, live critiques have helped me a lot. So because with the writing assignments, I have a draft before the final, time-wise, I have that class in addition to my first year class. I don't have the time to critique every written assignment. But what I do say is after you submit the draft, come talk to me for 15 or 20 minutes. I can quickly go through it and give you some critique on, 2 or 3 key substantive areas to go back and work on, and that's helped me out tremendously.
Thank you everyone for the questions. If you want to talk to me during lunch or whatnot, feel free to do that.